Hey, what's up? It's Stephen A. Williams, president and founder of creditrepairshop.com. I'm going to talk about some trending news about debt collection companies. One of the uh, big pieces of news is that debt collection companies over the last 11 years, 15% of them have closed. And something that I didn't know is that most debt collection companies only have about 5 employees. But what's been happening over the years is that they've been consolidating. So that's why you'll see all of these different addresses coming from the same debt collection company, or they might say, like, I think it's Calvary, will say Calvary SPV1 or SPV7, like that. It's because they got all of these different locations where they've kind of bought out, so to speak, other debt collection, or just taking them over, because I don't know, you know, what type of revenue a small one could make, but maybe they could do pretty good. It also said that regardless of how many accounts, they had a survey. This survey was done by TransUnion, and it said no matter how many accounts, if they had 100,000 accounts or if they had a million accounts, that the percentage of collecting from people remained the same. So it didn't matter how big a company was, didn't matter how many more accounts. Now, obviously, if you have more accounts, you're bringing in more money. But what they saw as something that kind of piqued their attention, at least in the survey, is that really no matter what you do, there's only going to be a certain percentage of people that you're going to be able to collect from. And that's why these companies are trying to buy these huge, massive portfolios, because really, when they buy them, they're not going to really collect more than the average amount. Maybe they might get lucky, but on average, they're going to collect a certain percentage of accounts. It was saying roughly about 61% of the accounts that they try to collect, they end up collecting something on those accounts. And I know just from experience that a lot of those accounts were not uh, accounts that people had to pay, but they were kind of, I don't, in a way, bullied into paying them. But that's just the way it is. Now, some of the other things that I found out, and before I move forward, I want to also tell you, yesterday I had a video where I talked about debt, and it said Experian batched. I reached out to the collection, or to the portfolio purchaser who sells it to all the debt collectors. This is what that means. When they say Experian batched or TransUnion batched or Equifax batched, that means that they've already traced the individual's information. So that batch, everyone in there, they know the address, they know email addresses, they know their Facebook page, they know their work, they know references. Everything has been verified for that batch, and they're selling that batch to debt collectors. So I'm going to start paying more attention to what that means, because the way that they're making these packages more attractive to debt collectors is that they're batching them, which means that they're tracing all the points about that piece of debt, and then they're selling it to the debt collector and saying, hey, you don't have to trace anymore. We've already done the tracing. You can just go ahead and start trying to collect it. Uh, Before I move on to the next thing, another thing that I found in this report, it was a TransUnion State of Collections Trends and Insights for 2021 and beyond. Another thing that I found uh, that was interesting was that when they have these degrees of challenges for debt collection businesses, and I know why the government and different organizations want to get this, have you do these surveys. There's one that I have to do for all of my businesses that is required by the federal government, and this was one that TransUnion did. I don't know if it was something that they I don't think it's required, but they probably wanted members to fill this out. But one of the things that caught my attention on here was that the top thing issue that they had as a company was acquiring and retaining good talent, good people to get on the phone, to call, try to collect. Stuck in the middle was communicating with debtors. So trying to call and communicate with them. That's in the middle. But way, 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 way down at the bottom, it said client audits. It said client audits was way, way down at the bottom. And I believe that the reason why is because most people don't challenge the information that a debt collector passes over either in court or either in a demand letter. They rarely challenge. This is what I talk about with my 3-letter pack that I give to people for free in my cease and desist collection activities letter, is that this is what debt collectors don't want to deal with, but they don't really care too much about it because most people don't challenge them with it. A YouTube subscriber put a comment on here earlier that I just responded to, and he had said that you don't have a contract with the debt collector, so you can just disregard it. Well, yeah, that's true, but most people don't challenge that. They just disregard it. So when they get that letter in the mail, that letter comes in the mail, they open it up, and it says that this is such and such debt collection company. We had this original debt from this original creditor. Uh, you owe this amount of money, and they have this little paragraph about it and what we're going to be doing and what we want to do. And then right underneath it'll say, if you disagree with any portion or all of this, you have 30 days to dispute it. Most people disregard and don't do anything. They understand they don't have any contract with them, or maybe they don't. Maybe they just shut down because they don't want to deal with the debt. But debt collectors depend on you not responding. They don't. If you simply just wrote, let's just say you just out and out just said, show me a contract that you have with me to even speak with me about this, and watch how they respond. They may just say that they don't even want to deal with this and just say that they're going to cease collection activities, or you just may not hear from them again. Taking that proactive step at the beginning makes a huge difference on the type of way that they're going to try to come after you for that debt. Most debt collectors will stop because they don't want to get into that back and forth. It costs them more money. Uh, there's no contract. They don't have all of the information that they were supposed to have, that they can even get from the original creditor, because they'll be violating certain things by even passing that information on to a debt collector. So they run a very slippery, like tight wire. Is that what you say? Yeah, like they're up on a tight wire, and they're like making sure that they stay balanced, because one way they can end up getting sued, another way they could just outright lose. So they want to just try to stay balanced on the middle. And in the middle of the survey, one of the top things, the number 3 thing that they worried about, was changes with the Consumer Finance Protection Bureau on debt collection rule making. And so if they the Consumer Finance Protection Bureau is always kind of doing some updating on what debt collectors can and can't do. It's not just the Fair Debt Collection Practices Act that they have to worry about. They also got to worry about complying with what the Consumer Finance Protection Bureau has in line for them. And mainly, it just deals with the way that they're going after people for debt, making sure that they get all of the documentation approved, that they can even do it, making sure that they don't cross any lines. And that's what I'm going to talk about next. In the next article, with the Consumer Finance Protection Bureau, the number one issue that they have, and a lot of debt collectors try to buy these small debt collection companies to do this dirty work, but a lot of them got caught, is that they'll try to send your personal information over, which is one of the ways that we fight uh, court summons from them doing this type of stuff. But they try to send that information over to third parties to do the dirty work for them, and then they come back around and they're where the money is actually going. Well, there's several lawsuits, but this is one of them. It's Houston versus Preferred Collection and Management Services. The debt collector transmission of personal information to a third party vendor is insufficient to state a claim under the Fair Debt Collection Practices Act for violation of 15 USC 1692 DB, prohibiting communications about a debt with a third party. Now, this is an issue where they try to intimidate people by sending information to your employer, by saying, okay, like a warm up letter. You can't send a warm up letter to an employer saying that, oh, does this person work here because we're trying to look for them because there's a debt that they owe. That is against the law for them to do that. And I've had calls for employees from third party debt collectors directly to my phone saying that they're trying to hunt down an individual that works for me. I'm not going to mention which companies. I own 4 different companies. But I've had that happen. And that is against the law. They cannot do that. They cannot do that. But companies debt collectors try to do it by, knocking on people's neighbors' doors. And yes, you will get that when it comes to big time debt like a auto repo loan or something like that, where they can, collect a lot of money. They will do it. They'll do it if it's maybe for a business debt that is personally signed. They will do it for large credit card debts that are out there. They will do this. They just have a sneaky way of doing it. And in my video yesterday, I talked about where I get information from people, and I do what's called a I call it stand back, but what it is I just calm down and I go into like a thought process. And in that thought process, I start waiting for potential solutions to start coming to my mind. And one of the ones that came uh, with the customer that was getting sued was where there was a document where the debt collector was trying to give the impression that that document came from the original creditor when it was a document that they prepared. But the way that they submitted it with the court case, it was like, man, they're really stepping this up, but they really wasn't stepping up. They gave an impression. And so with this type of stuff is the same thing. Like when I got information about a debt collector trying to contact me about a employee's debt and they don't have any documentation, they're just giving me a call or sending a letter without going to court, and they're communicating to me about a personal information about an employee, that is breaking the law. But they do that. They slip those little things into to intimidate people, and they can't do it. So if you have a debt collector and they're trying to pull these types of things, number one, sharing your personal information is not something that is legal for a debt collector to do. It is technically not legal for your original creditor to give that information to a third party debt collector. But you have to kind of craft your argument around that also. It's like you're throwing in, hey, they did this, and they also shared my personal information. Give me something that shows that I authorized the original creditor to share my personal information with them. So there are several cases that are going on right now, but let me tell you the problem. Let me tell you the problem. Right now with the Supreme Court, uh, it's slanted right now to help debt collectors. Uh, with any other Supreme Court before this would have been a slam dunk based solely on the sharing of your personal information with a third party without your approval. But it is on appeal right now, and the court remains divided on the standing of this. So there's going to be the way I look at it is that you're going to have to fight things like early. Like this here is like different than what you would actually go through. This is where individual was sued. I mean, the individual was, is taking it to the top level, trying to get a big judgment against the debt collector. For yourself, this is not the area that you would be in unless you want to try to take it that way, hiring an attorney and trying to see what could happen, and then going back and forth with appeals. But for you, where you're at is that you just need the information that they cannot share it. Most debt collectors, and probably with this debt collector, they stopped when they were notified of what they did. It's just that you know how sometimes we just want to take it to the limit. Like, I won this and now I want to, make you pay. And so that's what's happened with that. I will keep you up to date as I get information on that, to see what's happening with these court cases. Uh, yeah, it just says that it's a divided court on what they're going to allow debt collectors to do and not do. There is no final rule on it yet. No final rule. But you could safely say that according to the FDCPA, Federal Fair Debt Collection Practices Act, for violation of 15 USC 1692 DB, prohibiting communication about the debt with third parties. That is the number one thing that you can use if you feel that you were violated, your personal information was shared by a debt collector and also original creditor without your permission. All right, I'm going to end the video here. If you need help with your credit, please visit us at the Credit Repair Shop. Watch the video, the THE creditrepairshop.com. Watch the video, what makes us different. That's the way that we repair credit using my 8-point validation system, 8-point validation process, and my two-phase settlement process to settle outstanding debt. If you need your credit reports and scores, please go to the website your3scores.com. It has all of the information in the comments. You could see if a debt was canceled, where it's potentially a 1099-C coming your way. All of the furniture information from that specific address, even though it may have an address that you can look up online, you need to know the furnisher's address. And if it comes back undeliverable to that furniture address, you automatically can use that information to get it removed off your credit, because that is inaccurate information from the furnisher. If you need my 3-pack of letters, I give you all 3, but only utilize the one that you need. My statute of limitations letter for debt that cannot be collected because it's past the legal statute of limitation to collect in your state. The next letter, the cease and desist collection activities letter, which is what we just talked about right here, has that information plus more in there that you want to make debt collectors think about if they're trying to collect a debt from you. My debt validation letter, you need that letter because there could be back and forth play between you and a debt collector that is going to try to collect that debt from you. And also there's links to other services that I do provide below this video. Please make sure that you like this video. Please make sure that you subscribe to my channel. Uh, please share the information. And also please have a great day. Your debt is not you. Your credit score is not you. You determine who you are. Thank you for your time. This is Stephen A. Williams, President and founder of the CreditRepairShop.com.